What's up, YouTube? Derek Tent here in my garage. Late Sunday night, and I've got news about the FDA, about their regulations of cigars and pipe tobacco. And I've been sitting out here for a while, and I've been trying to think of a way to bring you the news without the video getting too long, because there's a lot of information to cover, but I don't want it to get too long. But there's hope. There's good news. The good news is that on Friday, a lawsuit was filed against the FDA seeking relief against their final rule that's supposed to go into effect next month. All these restrictions and regulations that are going to be levied against pipes, tobacco, and cigars, we're looking for some relief, and I think there's some hope there. A 40-page lawsuit was filed in Washington, D.C. in federal court on Friday, and I've read the thing a couple of times, and it's absolutely beautiful because it rips to shreds the FDA and their regulations on pipe tobacco and cigars. Oh man, it was a beautiful read, and I just want to hit a few of the highlights for you here. I don't want to take up too much of your time, but I think this is a worthy view. This is something to give you a little hope. Now, 3 groups have sued the FDA. All right, they've come together. All right, there's the CAA, which is the Cigar Association of America. They represent manufacturers, importers, and distributors of cigars and pipe tobacco. There's the CRA, which is Cigar Rights of America. It's a consumer group. Probably some of you are members of that. I probably should be members of that because they represent our interests. And then there's the IPCPR, the International Premium Cigar and Pipe Retailer Association. They represent about 2,000 brick-and-mortar tobacco shops and 35,000 employees. In fact, many of the tobacco shops around here that I go to are members. So you've got everybody in the industry represented, coming together. Manufacturers, importers, distributors, retailers, and consumers all together pitching in to get the FDA. And did they ever? The very first line on the lawsuit says, we seek declaratory, injunctive, or other relief from the unlawful final rule, which was published on May 10th, 2016 by the FDA. And they go on to say that what the FDA has done is contrary to the language and the purpose of the 2009 Family Smoking Prevention and Tobacco Control Act. Now that's what this is all about. The FDA got all of their authority to regulate tobacco products in 2009 from the Tobacco Control Act, from Congress. Now, but there was a lot of language in that act, in the Tobacco Control Act, basically telling the FDA that they want them to regulate cigarettes, roll your own tobacco, and smokeless tobacco, and gave them the authority to deem other products, if appropriate, if there was if there was a public health threat. And if they were to enact regulations, they were to be flexible, effective, appropriate, and they were supposed to continue to permit sales to adults. Because what this is really all about, what the Tobacco Control Act is saying, is that they just want to restrict tobacco access to children. And that's it. That's really the crux of it all. But they gave the FDA an inch, but the FDA took a mile. They took that authority that they were given, and they kicked the door down. It's like maybe giving the small amount of authority to, say, a mall security guard, and then the mall security guard wants to go out and start pulling people over on the streets and writing tickets. It's like, it's, a clear abuse of authority. And so this lawsuit is pointing that out. There were so many things. I mean, it was beautifully written, talking about how the user fees that are going to be that are going to go against pipe tobacco and cigar manufacturers are nothing more than an illegal tax that's random, it's arbitrary, and unfair. They talk about how the FDA did not do a cost-benefit analysis. They were supposed to do a study to figure out how it would affect the industry, how it would affect small business. And they didn't do that. They didn't care. They just said, well, maybe some jobs will be lost. Maybe that industry will lose some jobs, but it's so small, who cares? That is basically what the FDA said. I mean, and I'm not even lying. That is what they were like. It's okay because it's for the children. If jobs are lost, warning labels, violation of the First Amendment, impractical, stupid. And then there's the idea that they said if you're a pipe tobacco retailer and you blend bulk tobacco together, that makes you a manufacturer. And this lawsuit says stupid, ridiculous, wrong. Think about Boswell's. These are great These are great blenders of pipe tobacco. Are they manufacturers? No, they're just taking already manufactured pipe tobacco and mixing it together, maybe adding some flavoring, whatever. It's stupid. And pipes themselves, they want to regulate pipes. And they say that's ridiculous. This is not a tobacco product. This is an accessory. It's not a component. It's not derived from tobacco. So all of this, and the FDA is, they put out this 2007 grandfather date. If any tobacco product was on the market before that, not subject to regulation. Anything that was on the market after February 15th, 2007 is subject to regulation and has to be approved with an application. You got to send in an application for approval. Well, that application process is bogged down and ineffective. Thousands and thousands of these applications have been submitted, and they've barely got through a fraction of them, and they won't be through a fraction of them. So if I've got a tobacco product I want on the market and I've submitted an application, they're not going to get through it, and it's just going to become illegal at a certain point in 2018, and my application is still going to be sitting in their office. And that's ineffective, and that's what the Tobacco Control Act said not to do. So, in summary, they ask for 9 claims. There are 9 counts. There are claims for relief. Number 1, they say that the grandfather date of 2007 is arbitrary, capricious, abusive. It exceeds their authority. All right? I hear these words a lot: arbitrary and capricious. Arbitrary means random, without guidance and without standard. And capricious means, it's volatile, unpredictable. So that's what that said. They throw those words around to describe the FDA. So number 1, the grandfather date is arbitrary, capricious, abusive, and it exceeds the authority of the FDA. Number 2, it says the user fees are abusive and unfair. The 3rd count says that the user fees violate the 5th Amendment right to due process. The 4th count was that there was no proper cost-benefit analysis of the economic impact. And we do know that these groups submitted, they said in the comments that it would be devastating if those rules went through. It would devastate the industry. And FDA was like, okay. 5, it was a violation of administrative procedure for the failure to consider option 2. That was another thing, the option 1, option 2. Option 1 was the proposed rules would regulate everything, and then option 2, they would be able to opt out of premium cigars. They didn't even consider it, and that was a violation of procedure. Count number 6, warning labels are arbitrary and capricious. Number 7, warning labels on these products violate the First Amendment. Number 8, creating samplers and calling retail tobacco blenders, calling manufacturers, is arbitrary and capricious. And number 9, pipes should be considered accessories, not tobacco components. So all of that, they ask for the final paragraph is prayer for relief. They want this judge to vacate and set aside this final rule. They want it to be declared unconstitutional. They want a permanent injunction against it, and so that the FDA cannot come back and reactivate the rule. They want costs. They want their costs paid back, legal fees. And then number 5, they want any other relief that the judge can think of. So that's it. That's your lawsuit. 40 pages of 3 groups that represent our interests, just poking holes in the FDA's final rule, and just working on trying to get around that, trying to get that final rule set aside. It looks good. I'd have a hard time arguing with it. I'm no legal person. Well, legally I'm a person, but I'm not in the legal industry. But reading it, when you get past some of the references to the rules and all these numbers that they put on for, refer to this code and to this law. Once you get past all that, when you're actually reading it, it's pretty easy to understand, and I'm glad. I like it. I hope that there's an injunction put against this FDA rule, and we will be able to continue, as normal before all this. So if you want to check it out, I'm sure it's out there. I just Googled the IPCPR lawsuit. It's on halfwheel.com. I don't know. If you're still watching, we'll bless you so much. But I thought I would share a little bit of that good news for you all. I'll try to. I think there's a lot of people out there that are interested in this type of thing. So I'll try to tag in the comments some people who are definitely interested in seeing this. So I'm gonna go back to smoking my pipe. Appreciate your time. Thank you so much for watching, and I hope you have a great day.